So welcome to our 11th annual Codex FutureLaw conference. So it's wonderful to have you here with us today. My name is Roland Vogel. I'm the Executive Director of Codex, the Stanford Center for Legal Informatics. And we have an exciting day ahead of us here today. We have a tremendous group of people here who are driving many of the super exciting advances that we're seeing in legal tech in recent times. FutureLaw is our biggest conference every year, bringing together this growing legal innovation community from around the world. It's turned from a one-day event to an entire FutureLaw week. Actually, this is still our main event, but we started last Saturday with a boot camp on AI and social impact. We had a hackathon with our third LLM and law hackathon in less than a year. With record attendance also, and then we have a bunch of adjacent workshops, but FutureLaw is still our main conference and main event, this Thursday event here today. So we have a community that spans the globe and exciting new projects that are popping up in different countries around the world all the time. So what we're presenting here today is a snapshot of what our planning group feels are some of the most interesting topics and people that we want our community to be aware of. So before I continue and walk you through our program, I will turn it over to our Codex Fellow, Pablo Arredondo. He's been a Codex Fellow from the early times of the center. He's, of course, also a co-founder of CaseText and is now representing our conference partner, Thomson Reuters. So over to you, Pablo.
All right, guys. Well, thank you so much. Corporate sponsor is definitely a new thing for me, so I'll do my best on this. I just wanted to say on behalf of everyone, my colleagues at Thomson Reuters and here at the center, welcome to everyone. I think this time last year, we were sort of still under the sort of vertigo of what had been these really profound changes in technology. And over the last year, perhaps the dust has settled a bit to see just how much work we have to do, just how many different things we're going to have to navigate on the technical side, on the legal side, on basically every dimension in which you would have to navigate something. I think these new developments are forcing us to. So I'm thrilled to see familiar faces, and I'm thrilled to see new faces, and wish everyone a great conference.
Thank you, Pablo. So it's been a truly exciting year. It's also been a sad year. We lost one important member of our community, Monica Bay. She's been a friend of our center for many years, and she was an affiliate, and we'll miss her dearly. She was a real powerhouse. So anyways, with that, I will now turn to our program and walk you through our program. So first of all, you should all have received this little booklet, which has the agenda in it. It also has a QR code on the back side, and if you click on the QR code, it will take you to a link tree where you can see all the speaker bios, all the evaluation forms, although we also have printed evaluation forms, MCLE credit, parking validation, everything can be accessed through this QR code. Then let me walk you through the program. So we'll be kicking off the event with a keynote by Professor Dan Ho titled Regulation, Rights and Tradeoffs in the Age of GenAI. We will then have a very short break, so it's almost not worth leaving the room, just a very short break, and then we'll have our first panel discussion on the state of the art in legal tech circa 2024. After that, we'll have our second morning panel on GenAI and IP. And then just before lunch, we'll announce the winners of the 2024 Codex Prize. After lunch, we'll turn our attention to hybrid legal intelligence, bridging the neuro-symbolic divide. And after that, we'll be starting our Lex Talk session, where we have a series of short presentations on exciting and important topics and projects in legal tech. We have between our Lex Talks, we have a fireside chat on governance, risk mitigation, and distribution of responsibility in a new AI ecosystem. And we'll be closing the conference with a keynote by Professor David Engstrom. And then we'll all have a nice reception and some wine together. All right, so that's the program. We also, you may have noticed in our room in the front here, we have some demo tables where we demoing our Codex Insurance Advisor project, the Learned Hand, Margaret Hagan's Learned Hand project, and then Megan Ma's due diligence project. So check out the demo tables and let us know what you think. All right, so a few thank yous are in place, of course, to our Codex affiliates and conference sponsors, Thomson Reuters, AXA, DLA Piper, the Nonprofit Insurance Alliance, Nickel, and Casetext, although Casetext is not part of it. Anyway, all right. And then also, of course, the Stanford Center for the Legal Profession under the leadership of David and Nora Freeman Engstrom, and obviously the Center for the Legal Profession is a conference partner of the FutureLaw conference. All right, and then thank you to all our speakers who have decided to come here today and share their expertise with us. And then our Stanford Law School program group, especially, of course, Giselle and Maria, who have worked tirelessly to make this kind of smooth experience for all of us. All right, so with that, it's my pleasure to introduce our keynote speaker, Professor Dan Ho. Dan Ho is the William Benjamin Scott and Luna M. Scott Professor of Law here at the law school. He's also Professor of Political Science, Professor of Computer Science by courtesy, a Senior Fellow at Stanford's HAI Institute, a Director of the Regulation, Evaluation, and Governance Lab, also known as the REG Lab, through which he focuses on high-impact projects of data science and machine learning in public policies in partnership with government agencies. He serves on a variety of important national committees focusing on AI policy, including the National AI Advisory Committee advising the White House on AI policy, and in many other important committees. He's not only an accomplished scholar and researcher, but also a popular teacher here who won several teaching awards for his unique teaching. And I could go on and on. Dan has a JD from Yale Law School, PhD from Harvard University, and he clerked for the U.S. Court of Appeals for the District of Columbia Circuit. So without further ado, Dan, thank you so much for accepting our invitation. Please join us up here. Please join me in welcoming Dan Ho.
Thank you so much, Roland, for that really kind introduction, and to Pablo as well for the welcome. And I'm really pleased to welcome you all to Stanford for this event. It's fantastic to see how much this community has grown over time. I'll start off with a disclaimer, which is that nothing I'm going to present reflects the views of any governmental agency, and they are just my personal views. That's my obligatory disclaimer. We're in this really unique moment. We can take, if this clicker can work, could we maybe advance the slide? All right, thank you. We're in this truly unique moment where we have a blank page, a blank canvas on which we can paint. There we go. So we can take the director of the program on law, science, and technology, Mark Lemley, go to a kind of platform, if we can. I'm going to just ask folks to, this is going to be the very awkward replication of the dynamics of a Zoom conference where I'm going to have to say next slide every 5 seconds. But we can take a kind of a platform, take our beloved Mark Lemley, combine him with an image of Star Wars, and get a great image of a younger Mark Lemley using a lightsaber. And I know that's the image that many of you may have in mind when you think of Mark Lemley. We can prompt similarly for things like Justice Scalia playing tennis at Wimbledon and get fairly realistic images, although he seems to be holding the racket somewhat poorly, and it's not clear he's keeping the eye on the ball, but he's dressed in white, appropriate for Wimbledon. And just in 2005, when Carl Branting gave a keynote address, he said, he lamented the state of legal technology and said, there's not a single system that comes even close to being able to answer queries like the below. I won't read through all of this, but this basically, if an employee hasn't received a kind of paycheck, sort of who is liable, sort of ChatGPT does actually fairly well in terms of being able to answer that challenge that Carl Branting laid forth less than 20 years ago. At the same time, all of us recognize the really significant limits of the technology to date. Look no further than the ChatGPT lawyer, who submitted a brief containing some half-dozen bogus citations, and was interviewed by the New York Times and said, quote, "I did not comprehend that ChatGPT could fabricate cases. He simply thought that the technology was far ahead of what it could actually support." And this turns out to be, as probably all of you in the room know, a pretty pervasive phenomenon. When we did an evaluation here at the Reg Lab to assess the state of legal hallucinations, across the top kind of 4 models, legal hallucinations were between 60 to 90%. So we have a lot to tackle as a field. And over the past year and a half, we've had a sharp rise in interest to actually thinking about regulation and policy responses to the rise of ChatGPT and the like. We've had the EU AI Act finalized. The White House issued in November the AI executive order, followed up by the now finalized OMB memo on government agency use of AI. And California alone has some 30-plus proposals for AI regulation alone that came in about 2 months ago. So I'm going to make 2 provocations to start off this conference, 2 arguments that really sit at the intersection of law and technology. And the 2 arguments are really as follows. One is that as we've seen the rise of these calls for AI regulation, there are certain rights-based frameworks for AI regulation that have actually failed to learn the lesson from the Supreme Court's journey in procedural due process. And I'll try to articulate to you what I mean by this. And second, when we move from principles to practice, we're going to necessarily have to confront the trade-offs that are otherwise ignored. So we can have policy proposals that call for AI that is safe, effective, unbiased, privacy-protecting, and has 0 environmental emissions. In practice, any deployment instance is going to have to trade off amongst these things at the frontier. And the question is how we make that transparent through technology and responsible integration within human systems. And that really requires very active science at the frontier of the technology. So let me spell out those 2 provocations and give you a sense of what I mean. 1, on due process, For those of you who are lawyers in the room, trained in the American system, there's a kind of pivotal case that sets out procedural due process rights for when the government affects liberty or property interests. Goldberg versus Kelly was a kind of seminal decision that said that when a welfare recipient was going to be terminated, because of the kind of property interests implicated, it would trigger a set of procedural due process rights that from the Goldberg versus Kelly court included notice, the right to a quasi-judicial decision, the right to be able to challenge the basis of that decision in the forms of cross-examination and the like, and was described by Owen Fiss as, quote, reason in all its splendor. So you made a binary determination of whether rights, liberty and property rights typically were implicated, and that triggered a set of procedural due process rights. But what the Supreme Court learned over the course of time of trying to apply that framework in a range of different government programs and services is that it became incredibly difficult to treat that as a kind of binary on-off switch that triggers a full set of procedural due process rights. And it scaled that back really via a decision in Matthews versus Goldberg, which tries to balance the individual rights at interest and the governmental rights at interest. The critique of it is that it ended up being this kind of factor test in search of a value. That's a quote by Professor Jerry Mashaw. But it really was the Supreme Court's lesson in the difficulty of applying a kind of binary rights framework. And the argument I have is that we are at risk of replicating the same mistake when it comes to AI regulation. Many people think, including Professor Jerry Mashaw, that procedural due process as a project has really run into some sharp limitations. This is the file room of one of the agencies just as of a number of years ago prior to when it went digital modernization. This is the Board of Veterans' Appeals, which hears appeals by veterans for the denial of disability benefits, where individual veterans law judges have to read every single page in the record, and one estimate has it they have about 10 to 15 seconds per page to process really complex materials. In another setting in the Social Security Administration, some folks have referred to the failure of the procedural due process project as a form of disability roulette, where if you take the award rates here on the x-axis, where cases within a region may be randomly assigned to adjudicators, there are these dramatic disparities. Going back 50 years ago, that was something that Jerry Mashaw documented, where the identity of the judge may matter more than what the facts of the case are as to the determination of whether or not you receive the benefits. And within unemployment insurance, to which 46 million Americans turned during the time of the pandemic, in part because of the sort of lock-in effect that I'll describe, we relied on a kind of system of human adjudication that really collapsed exactly at a time when folks needed it. So at baseline, the timeliness of unemployment insurance checks was above 90%, around 95 to 97%. And as the pandemic hit, as people were filing in droves for unemployment insurance, timeliness dropped to like just above 50% really early on in the pandemic. And that's the challenge, that is a challenge that sits at the intersection of technology and law. And my provocation here is that we are at risk of replicating that very mistake. I'll give you the example. The example is the initial memorandum by the Office of Management and Budget under the AI executive order that was meant to govern how federal agencies utilize forms of AI. And it made a similar move to the Goldberg Court, and it said, for anything that's a form of rights-impacting AI, we're going to have a set of minimum practices that have to be met. And here's our definition of rights impacting AI. It's whenever the output serves as a basis for decision or action that has a legal, material, or similarly significant effect on rights. And then there's a set of enumerated instances that are rights impacting, including, quote, access to government benefits or services. Right? And what happens if you're deemed to be rights impacting? Well, it triggers a set of, quote, minimum practices under that first draft. Those minimum practices look a heck of a lot like some of the Goldberg protections: public consultation, notice, explanation, the right to appeal, contest the AI-specific role in the decision, and the right to opt out for a human alternative. You can see where this is going. I'll give you two arguments as to why this binary determination that triggers a minimum set of practices could be deeply problematic. One is, government benefits and services are vast and varied. So let me give you just a sense. This is what led to the Matthews retrenchment. The National Park Service has to deal with 3 million campers and 27,000 campsites, and one of the government services and benefits is handing out campsite permits. Another is that the US Postal Service handles 128 billion pieces of mail a year. That's a government service. The National Science Foundation administers some 40,000 applications for federal grants annually, some of which are very low dollar value in the sort of thousands or tens of thousands of dollars. And argument number two is that what this really challenges is the fact that AI can be integrated really fairly deep in the software stack of how these programs are actually administered. So in one piece, we describe what we call the sort of gradient of AI integration, where you can have really basic forms of process automation, like whether an email is forwarded to the particular right person. And what people have in mind when they say government services is sort of full-blown auto-adjudication where there's not a human being touching this. The reality of most federal programs is that AI is being integrated somewhere in that mid-range. And the sort of potential influence on the outcome can really vary where in the software stack or where within that gradient of AI integration you're bringing forms of machine learning in. So what do you do with forms of improved OCR? What do you do with document interpretation and translation? Down to anything else, and where do you draw that line? That's the same struggle that Matthews versus Eldridge wrestled with in terms of trying to draw that line. And so to give you an example, when Jen Polka and several others and I wrote a letter to OMB on this, what does it mean to be the basis of decision when the United States Postal Service, since 1965, has used optical character recognition to try to actually automate the reading of zip codes to figure out whether the right postage was made and whether the mail is being routed in the right way? And if in fact we think that that's a kind of government service that triggers a range of these procedural protections, what the right to appeal and the right to opt out would mean is that anytime you walk down to the postal office, within the sort of counter, you might say, I don't believe this zip code recognition, I would like to opt in favor of a human alternative, and what you would have is the Postal Service having to increase its hiring really dramatically simply to have human beings read zip codes. That cannot be the right answer. Nor can it be the right answer when it comes to AI innovation at the Social Security Administration, where a guy by the name of Gerald Ray, who was chief of the Appeals Council, did some really fantastic innovation work, where, for instance, one of the things that they did is they did a form of what they called micro-specialization, which basically meant they did really sort of forms of clustering based on the metadata, so that judges, instead of crisscrossing from one complex area to the next, could decide all knee injury cases for the first few days of the week, then turned to all musculoskeletal disorder cases, and found that that actually had real benefits. That simple form of like reordering, the same cases that judges would be deciding actually both seem to accelerate decision-making and reduce errors. It cannot be the case that that sort of unsupervised learning is a form of AI that triggers a kind of opt-out. And then the more interesting questions come up when the Social Security Administration builds out something like a natural language processing system that allows their judges to upload draft decisions, and it spits out anywhere up to 30 quality flags, ranging from really simple things like you have cited a provision of the US Code that does not exist, to internal inconsistencies between factual findings and legal conclusions reached. And that, I think, is the challenge in the way we're approaching forms of AI regulation. A fantastic book on this front, and the ways in which that kind of an approach can really lead to locking in forms of government technology is by Jen Pahlka. But it isn't a technological challenge alone. There's a chapter in this book that describes, it's called 17 Years, and it involves Marina Nitze interviewing folks who are doing unemployment insurance claims adjudication. And there's a guy who calls himself the new guy, and Marina kind of goes up to him after sort of observing his process and says, why do you refer to yourself as the new guy? And his answer is, you know, compared to the people who have 25 years of experience adjudicating unemployment insurance claims, I still don't really know the ropes. And that's not a technological change. That's a change where trying to really think about the frontier of the technology may help us streamline some of the ways in which these systems really should be modernized, and the ways in which we fail to confront these kinds of trade-offs when taking this kind of a due process approach. The last example I'll give to you is from, again, returning to the Board of Veterans' Appeals, where one of the failures of this kind of process-based approach has been that we have courts, in the guise of adjudicating individual cases, making decisions about large systems. In the Veterans Administration instance, you might have a single appeal being decided by the Supreme Court, where a decision that says that, hey, Mark is entitled to get this medical diagnostic actually means that what you're shifting around is health care between 2 million veterans who are in the queue against another set of veterans that are going to be pushed back in the queue. And courts are extremely ill-informed to date to be able to make those kinds of decisions, or as put by the chair of the Board of Veterans' Appeals, each time you breathe out, the VA has just produced another medical opinion on a claim. But therein also lies the possibility, which is if we think about the integration of technology, it may actually allow us to confront these trade-offs in much more meaningful ways, which leads me to the second argument of how we actually think about law and technology as a possibility space to confront these kinds of trade-offs. I'll give you an example from some work that we did with the US Department of Labor, which administers workers' comp for all federal workers. It's a fairly large program. It involves up to $3 billion of annual expenditures, but the error rates are fairly high. And what we built out with a team here at the Reg Lab is really a model of AI assistance for claims examiners. And the model essentially allows claims examiners to sift through volumes of medical records to figure out what they should prioritize that may support a claim of continued eligibility of workers' comp. And I won't bore you with the details of the model, but the model is essentially a document ranking model and then a span identification model so that you can order which things you look at first and what you look at within a document by highlighting the relevant passages. But the trade-offs, there are trade-offs in the design decisions here that we're all probably pretty familiar with. The reality of integrating a model like this into a complex bureaucracy means it is a tiny sliver of what the system actually has to grapple with. So this is a flowchart of the actual kind of decision process that required you to think about the healthcare interaction of who are the physicians and what's the nature of how they're actually reporting through this medical documentation to the training of a unionized workforce and how you actually integrate training towards AI systems and the like. And we oftentimes spend a heck of a lot of time in that lower left corner just thinking about the technical details, but the actual kind of responsible integration requires you to think about the system as a whole. And I'll give you just two examples here of how to think about these trade-offs. One is on the data quality side. The kind of naive way to approach this is just to take historical data of how things have been adjudicated, but the problem with that is that these are exactly the kinds of systems that have been ripe with error historically. And so one of the things that we were able to do for this project is take a kind of team of senior claims examiners, re-adjudicate the claims to really give us high-fidelity labels rather than dealing with an incredibly messy, noisy labels problem. And then to have a similar team in the evaluation actually re-adjudicate these cases through a kind of post-intervention audit. That's a kind of way in which you really have to think about the trade-off of the resources that you have available for creating high-fidelity data. We then rolled it out in a kind of UI system. And the other example I'll give you here is that there are all sorts of trade-offs that are typically left to the engineers. Here, what I describe as a form of model alignment, one intuitive way to think about that is just how much do claims examiners actually want highlighted in a document? You could overwhelm people with highlights and they won't use it at all. You could have too few highlights. And here, one of the really interesting technical solutions has been from colleagues here who are collaborating, really to try to think about ways of soliciting feedback on model types that that basically do the same thing as RLHF, but through direct preference optimization. And so that allows you basically to, in a kind of trial period, show pairs of highlights, get examiner feedback as to what do you actually find more helpful, and that really allows you to kind of fine-tune this model in a way that is most consistent with what claims examiners would find to be helpful. So let me kind of end, and we may have a few minutes just for Q&A, and let me end with kind of three remarks. I think it's really important as we start to turn from abstract proposals for AI regulation to actual integration of how we actually confront these trade-offs. So one of the sort of elements of the OMB proposal that I had started off with is the requirement for agencies to consult and have essentially what some people think of as forms of notice and comment for any kind of AI proposal that's being integrated. And that's something that OMB memo starts off with AI, with agency use of AI, with the similar kinds of proposals being made for kind of private sector technology as well, depending on the domain. And the real challenge and open question in the field is, how do you do that in a way that is sustainable, that is cost justified, that actually gets you the right kind of input? As somebody who teaches administrative law, we can look to the bad examples of notice and comment, like the network neutrality proceeding, where in part because John Oliver set up a site for people to directly submit comments to the FCC and the rise of millions and millions of bot-generated comments, the FCC had to grapple with 22 million comments. Very few people think that the vast majority of comments had any benefit for a decision on network neutrality. And here's where the frontier lies in terms of really interesting technological solutions, because something like DPO, direct preference optimization, is in a sense a way in which to transfer the decision authority away from engineers towards soliciting preference input from the folks who are engaging with this technology directly, in the example of the Department of Labor, the claims examiners themselves, to really sort of align the model and in a sense consult. And we need more of that kind of work. There's currently an AI executive order to think about the modernization of notice and comment, and I do think there's very promising kind of paths there to think about using generative AI to actually distill complex rules for more effective citizen engagement. Second, when you think about accuracy trade-offs, it's not easy to get a federal agency or to work with a partner that's willing to take some of its most highly skilled staff to essentially provide forms of labeling and to audit the kind of pilot. And that's the kind of fundamental trade-off here in terms of cost. That is, if you go by early versions of what the EU AI Act said, which is training data has to have no errors, that's going to be extremely costly. And we're always navigating that trade-off. And what that meant here is the lowest cost thing would be just to use historical training data, which is problematic because we know that this is a system that is prone to error. You could have a specialty labeling team. You could have a specialty labeling team in a post-pilot audit. You could have a post-decision audit once this thing gets integrated. And the problem with that is it's converting an agency that really is supposed to have solo adjudicators on the front lines essentially into the equivalent of a 3-judge panel. And how to draw those trade-offs is sort of the interesting open question. I think some interesting uses of technology here are to actually provide automated forms of peer feedback, where you could imagine the same highlighting that we did to actually provide feedback on how other examiners might have handled a particular case, or whether other examiners would have relied on a document differently. And the last example is kind of in evaluation trade-offs. The OMB memo requires that we have evaluations of these forms of technology. I think benchmarking here is really important for this community in particular. We offered legal bench, but it's really difficult when we have tools that are only provided on a licensing basis that are really difficult for third parties to evaluate, for us to get to the bottom of claims like the fact that, or the claims like that legal hallucinations have been solved in legal NLP products. And that's a really big challenge for the field. One medical journal wrote that despite the large number of medical machine learning-based algorithms in development, few randomized controlled trials for these technologies have been conducted. At the Department of Labor, we worked with them to actually construct such a randomized control trial, and we were able to show that amongst the kind of most difficult cases that involved free-form kind of submissions, there were pretty substantial improvements in the reduction of eligibility errors and improvement in the documentation quality. But we need methods of how to actually move these kinds of evaluations into something closer to real time in the presence of things like soft labels, or to draw on advances in adaptive trials and the like. So to conclude, I think ultimately it's really difficult to get away from where the Supreme Court ended up in Matthews versus Eldridge, where we can have the kind of approach proposed by OMB that once it involves government services, we're going to trigger this panoply of rights. But in practice, the responsible and really difficult thing to do is that we're going to actually have to confront these trade-offs based on what's technologically and legally possible as these things get rolled out in practice, and to actually balance. Thanks. That's it.
Thank you. That was super interesting. I come from Europe, and on the due process question, we have the exact same debate, which is a bit different in the sense that for us the decisive question is there a sort of a black box problem in the administration using AI? Because then you run into the problem that accountability is difficult, and the challenge later on is difficult if you cannot figure out, which out of the million data points was the decisive one for the administration not giving you the camping parking permit or whatever you gave as an example. So I was wondering, question to you is, is there maybe for that dilemma, is there maybe a technological solution itself that technology can solve the problem that technology created in the first place? In other words, can we, in the sort of possibility of challenging the decision or seeking redress later on, can we use AI maybe to overcome the problem that we created in the first place?
Yeah. It's a really great question. I guess I have two answers. I think you're entirely right that the same problem I illustrated with the draft OMB memo exists in forms of the EU AI Act in terms of what is deemed to be high risk, right? Because within the high risk classification, essentially you have a kind of government benefits kind of category. And that really obscures the fact that you can have anything from auto adjudication to the kinds of lower level AI assistance that I would argue are the virtuous ways of bringing this technology in to modernize these kinds of systems in responsible ways that the Social Security Administration, for instance, practiced. It cannot be the case that unsupervised clustering simply to reorder the claims triggers a kind of opt-out and the like, because it would basically kill forms of public sector innovation. On the other part, I think my short answer to the core question that you asked is that I think the advances that we really need are on the evaluation side. And that involves not just benchmarking within legal applications, but advances that are really, in a sense, at the intersection of machine learning and causal inference to allow us to actually benchmark the influence of AI integration on actual outcomes. And that may lead us in different places. There's one fantastic study done by Jim Greiner and Kosuke Imai who basically look at criminal risk assessment scores in the criminal justice context. And they show, at least in the setting that they study, that judges completely ignore the risk assessment scores. And that has pretty profound implications for how much attention we should be putting. If it's one part of a very large kind of pre-sentencing report that is largely ignored, that is a very different valence than when we might make the decision in the abstract as to what safeguards need to be taken. It's obviously one of the most controversial domains for right reasons. But I think we need more of those kinds of evaluation efforts rather than trying to, in the abstract, make a determination that AI in anything that has to do with government services is automatically high risk because it fails to learn the sheer variety in AI systems and the sheer variety in government services and programs.
So I would just say that don't forget that in reality, in the real world, in terms of education systems, there's always a lot of fraud. And then in terms of facts that are presented to adjudicators, people lie. And so I would just say keep that in mind, because as I think of how I can use any of this stuff in a real world court system for high volume cases that have a lot of very similar fact patterns, when you're making credibility assessments on a daily basis, it's like, don't forget that these systems are dealing with data that requires fraud detection and lie detection.
Yeah, fraud detection has obviously been a very large application area for a large number of government programs where AI has been brought in. But I think your question also raises something really interesting, which is that there are certain bases of these decisions. If you are having to do to really make credibility determinations, that those are exactly the kinds of things that we may trust adjudicators more on. And that, I think, is the really interesting kind of implication of some of the ways in which the procedural due process jurisprudence that I mentioned at the outset has kind of moved, right? Which is that the emphasis has been so much on the accuracy of decision-making. But I think if you go back to Goldberg versus Kelly, some of the, like we could get to an AI system that actually has high accuracy, but there are going to be instances where the actual hearing and credibility determination and the human interaction values much more and is the kind of thing that really complements what you can do technically.
And that's not going to be accurate when you have issues of gender. For example, when you've got someone making decisions in family court or domestic violence and they don't believe women and they're not even aware of the fact that they don't believe women, when women go and ask for restraining orders but they're not being believed,
Yeah, it's absolutely the case. I mean, that's one of the things I did not mention about the OMB memo that's really important is that there's also a kind of evaluation component on demographic differences, which I think is actually absolutely crucial. Thanks.
All right. Well, Dan, thank you so much.